Episode for higher GC News. Mima Obibia Akwaba had the latest hot enamede Bramo. And until so you subscribe to channel idea, Bomodia say over subscribe. The way I say over click the subscribe button, you know. Now what barely notification. We have a video for be upload when the first person once Ebeka a video. Afi we are now what like video no give us a thumbs up now fi share my for so that when you be here now we and somewhere also Ghana memo hadum. Afi yimbura ye semwa abeto yapono so yinkuti a report here about to mama yiti answer.
I know Professor Atuguba once did a paper on it, and when he released it in Gimpa some years ago, you know, it brought the judiciary to their feet. I remember Chief Justice Kufo then, our beloved Yasantua, telling Professor Atuguba to, you know, be more nuanced, to put, salt. The phrase was to make sure that his statements were said that were nuanced and more acceptable, but not to make it so categorical that the judges tend to vote for the presidents that appoint them. Yes, Justice Duche also came in, but he was more measured, and then, so you see how far we've come. So Atuguba's paper is there. At least he has done a research paper. It's more rigorous than the anecdotal evidence that we are giving. But listen, nobody can fool me, and nobody can stop me from making the point that overall, generally, it goes when it comes to the matters, when it comes to the crunch. Let's separate the topics. There are those that generally go for a better society, like the cases that I've done, the people number 1, number 2, number 3, etc. Yes, those are not political. But we are talking about the hard cases. When it comes to the hard cases, it's politics. And let's not forget that even in the selection process, the presidents usually choose judges who share in their viewpoint, judges who share in their philosophy, judges who have their own, they share the same philosophy. That's it basically.
But the minority in parliament also addressed the press this week on this same matter of the petitions against the Chief Justice. This is Alexander Afenyo Markin some few days ago. Take a look.
Event at the residence of Reverend Ntim Fojo leaves so much to be desired. Very unfortunate. In any event, they could have used due process of law to, invite him. And then the final point, government must focus on issues of governance, creating jobs, and helping better the lives of the people. We are still aware that a lot more are being dismissed from various state institutions that are even very independent and are limited liability companies, and whose budgets do not rely on government budgets. We are also concerned about an attempt by certain individuals in government to push for the removal of the Chief Justice. The judiciary should not be seen as part of the partisan political system in our country. All we need is to have an impartial judiciary to dispense justice. What is happening is unacceptable, and it's clear that the NDC government wants to infiltrate the judiciary and make it partisan. But my advice to all judges in the country: stand together. Let not somebody create an impression of one of you and think that by dislodging one of you, you will be the next. The next day, you would also be the next. The judiciary must stand as one body and make a full statement to condemn this act. The Ghana Bar Association must also stand for the judiciary. Civil society organizations must stand for the judiciary.
As Alexander Afenyo Markin there, and Let me start off with Professor Asante Bediatuo on this particular issue and what the minority is saying. You heard Alexander Afenyo Markin make that particular point. Already, we know the process is in place or ongoing. As far as we do know, the Chief Justice has responded to the petitions against her. The consultation with the Council of State, as enshrined in Article 146, is ongoing by the President. As to whether a prima facie case has been established or not, it is not public, so we do not know, even though there's been some publications pointing to that effect, and the minority also referencing some allegations that they say is contained in the petitions against the Chief Justice. But how things have played out, and especially the concerns that have come up, does it have any merit in there, in governance?
Yes. So let me speak as somebody who teaches governance and leadership and has undertaken a lot of research in that area. I mean, frankly, if we are really interested in nation building and the development of Ghana, then we should all be worried about this incident of wanting to change appointees when new regime takes over. And it is not something that is being done or people want this particular regime do. It is something that has characterized the conduct of our governance and politics from 1992 up to now. It is my view that there can be no meaningful talk about development if there isn't some form of stability. So, a nation that wants to develop cannot develop if it is always changing. Okay, so people are appointed, new government comes in, they change. People are appointed, new government comes in, they change. Generally, my general view about that is that it does not help us in our quest to build strong institutions and in our quest to ensure that there is a needed, people build the needed competences and people stay in office permanent enough to gain the needed experience to be able to serve the nation well. You see, in countries that believe in coalition, coalition government easily crumbles. And when coalition government easily crumbles, sometimes these countries are able to run on their own even before new elections are held, and they succeed because the officials in the country who are not politicians may have been able to stay in office for long, garnered the needed experience and competences such that government comes, government go. Whether there's government or not, they will be able to run the country well. So I'm saying that we should be aiming at ensuring that we build institutions such that regardless of who is in power, okay, there are people there who will be able to serve the nation. Very important. So I am not so much enthused about the practice of always wanting to change appointees when new regimes, get into power. But let us interrogate the issues very well. Now, who caused them? Why is it that these things are going on? The point is this: it is because of the mode of appointment of these officials. We must begin to interrogate them. If we are going to continue to appoint judges like the way we've been appointing them, then we would always continue to face this kind of challenge. Okay? Elsewhere, judges are appointed after they have written competitive exams. Elsewhere, judges are appointed after they have attended some interviews. Elsewhere, judges are directly elected by the people. Now, we have fashioned out a kind of constitutional arrangement that allows the president to appoint, he said in consultation with the Council of State, the Council of State Judicial, and in consultation with a body that the president himself has a hand in determining its composition. Now, and the challenge has also been that when this power is of appointment is being exercised, it is exercised in a manner that does not fully satisfy the Weberian conception of meritocracy. And so what happens is that you want to appoint a chief justice. There are so many senior judges on the Supreme Court, but the appointment power is exercised in a manner that disregards these seniors. It disregards the contribution of seniority and people who have been there for long. So they will say, well, it's a political appointment. So they will go and pick somebody who doesn't have that kind of experience, who has not been there for that long, and who has not garnered that kind of competences. They will just appoint you and then say, we are making you the chief justice. Now, if you do that, first of all, your seniors begin to question you. Secondly, the idea of meritocracy, you not meeting that requirement comes in. Okay? And once you yourself know that, look at the fact that I had people who were senior to me there, and I've been appointed over them, I've been chosen over them. Once you yourself appreciate that you've benefited from that kind of political grace, you tend to now want to sing or dance to the tune of your appointing authority. And so soon after your appointment, you see how the comportment and the conduct and the public utterances and the attitude of these appointees, who would always do everything possible to please their appointing authority. Why? Because the appointing authority chose them over their seniors. Now, the moment you begin to do that, then you make yourself a candidate for efforts to remove you anytime power changes hands. Because given the way and manner you are appointed, and given your own feeling of wanting to show gratitude to your appointing authority, you would publicly, or yes, you would conduct yourself in a manner that would make people see that, look, you are only dancing to the tune of your appointing authority, and you are not asserting the principle of your independence or judicial independence. And so when that happens, you tend to create in the psyche of the people that you are for your appointing authority. And it is unfortunate that in Ghana, appointees up to now haven't developed or haven't learned or haven't been socialized into the practice of learning to serve the nation rather than serving government. Okay, people appointed would always want to please the appointing authority rather than serving the nation. Now, the moment you decide that, look, I won't serve the nation, but I always want to dance to the tune of my appointing authority, then you make yourself a candidate for removal. When the next election, produces a different result, because no government would also want to see a judiciary headed by people who clearly are doing the bidding or did the bidding of a former government. And the other bit is that, look, people must learn to gravitate towards where there is power. What I've seen is that in the Ghanaian public service, even when power changes hands, people are not intelligent enough to know that, look, my bosses that brought me here are gone, and so let me go then serve the new boss. They don't know it. And so what happens is that there are anecdotal and also empirical evidence of some of these people who were previously appointed doing things to sabotage the newly installed and invested regime. And so when this thing happens, to prevent that kind of sabotage and all that, then the new government would also want to ensure that these things don't go on. And so then they would give in, or people would make petitions. Okay. People who love the regime would want to make petitions that you are changed so that there is no sabotage. All these things do not help advance our democracy and good governance. And so I am not happy with the fact that we would always want to change, but there are reasons why some of these things happen. And so my view is that let us, as President Mahama has resuscitated the constitutional review process, I am looking forward to a certain recommendation that would help us, or would be in the direction that let us rethink the mode of appointing certain officials of state, especially when it comes to judges and then the Chief Justice. Let us rethink it so that, number one, we will appoint people based on the Weberian conception of meritocracy. If you're appointing, you should be sure that the person, how do you feel as a young judge who has been made the Chief Justice when your seniors, people who taught you, people who have garnered all the experience and competence are there, and then you are just made to benefit from that kind of political grace? Okay, meritocracy also includes experience. And so the recommendation that I'm expecting from the Constitutional Review Committee that has been put in place by President Mahama should look at how judges are appointed, and we should focus on meritocracy. And then when the person has also been appointed on merit, let the person who gets into office assert himself or herself in the discharge of his duty or her duty such that people would appreciate your independence. Now, you should not play to the gallery. You shouldn't be seen that, well, because it is Party X that appointed you, you are doing things in a manner that pleases only that party that appointed you. We are here in Ghana and we heard this cliche of unanimous FC. It created a very bad image for the judiciary, that because their heads or their bosses were appointed by the ruling government, they are always playing to the gallery, and when a matter is given to them, the empaneling and the verdict of the judges clearly show that they have taken sides, in a manner that does not guarantee their own independence and their survival and their own permanence in office. So it is important that we look at some of these things holistically, such that we will be able to be inching closer to the quest that we build institutions and actually strengthen them. Because this practice of we always want to change, it will not help. It will not help anybody. But I'm saying that the practice of we would always want to change would fester and will continue so long as we do not rethink the mode of appointment of judges, so long as the judges themselves conduct themselves in a manner that gives them out as having taken side. If you take side, then you do not expect. Now, President Mahama must go according to the implement the work of the oral committee. But those who have stolen from us, they must be brought to book. But if the president does not trust the judiciary, then it becomes difficult, because then the idea is that if you go there, they will frustrate you. So it is important that we do things that would bring about public trust in the judiciary, such that regardless of whoever is in power, we can trust that the judges and the judiciary will act with some sense of competence and independence. Other than that, if we overlook this, then the practice of always wanting to change would continue in a manner that would undermine our quest to build strong institutions.
Well, and on this particular path of the Constitutional Review Commission, because it's an exercise that is ongoing already, Lawyer Martin People is joining us on Zoom. And I know, Counsel, this is a particular position that you have supported in the past about the Constitutional Review process, taking a look at the appointment of the Chief Justice, that power taken away from the president if we truly want the judiciary to be independent indeed, not in words alone. Correct?
Absolutely, Mr. Kansi. Absolutely. Because we've all seen that for all the arguments that Professor Agyapong is raised, we've actually seen that that's been our history, that is shown that some judges are not able to hold their independence, okay? Yes, once they get the appointment, then they seem to pander. Others have held it well, but look, if we are speaking bluntly, overall, we all know that generally the judges would, seem to defer to the presidents that appoint them. That's the overall picture. We are not saying that 100% that's what happens, but we mean generally. And you know, Professor Atuguba once did a paper on it, and when he released it in Gimpa some years ago, you know, it brought the judiciary to their feet. I remember Chief Justice Akufo then, our beloved Yasantua, telling Professor Atuguba to, you know, be more nuanced, to put, salt. The phrase was to make sure that his statements were said that were nuanced and more acceptable, but not to make it so categorical that the judges tend to vote for the presidents that appoint them. Yes, Justice Duche also came in, but he was more measured. And then, yeah, you know, so you see how far we've come. So Atuguba's paper is there. At least he has done a research paper. It's more rigorous than the anecdotal evidence that we are giving. But listen, nobody can fool me and nobody can stop me from making the point that overall, generally, it goes when it comes to the matters, when it comes to the crunch. Let's separate the topics. There are those that generally go for a better society, like the cases that I've done, the people number 1, number 2, number 3, etc. Yes, those are not political. But we are talking about the hard cases. When it comes to the hard cases, it's politics. And let's not forget that even in the selection process, the presidents usually choose judges who share in their viewpoint, judges who share in their philosophy, judges who have their own, they share the same philosophy. That's it basically. That is what we usually say in common parlance, that this judge is NDC and that judge is MPP. That's what we say in common parlance. But if you want to put it intellectually, you would say that they share the same philosophies, the same vision, okay, the same ideology,
but
the
Martin,
same
not to cut you, but you see, Martin, you can share in the philosophy of the president without being a bootlicker, because we know elsewhere judges are appointed. Yes, no president want to appoint a judge who is openly opposed to him, but elsewhere judges are appointed. And you have the judges asserting themselves. If the appointing authority is wrong, they will say that you appointed us, but this one you are wrong. And so it is good to have people appointed that who share your philosophy. But the point is that sharing a philosophy of appointing authority is not the same as being seen as a bootlicker and always doing the bidding of your appointing authority. If you do that, then constantly our judges would always be candidates for attempts at removal.
Well,
okay. Yes. Okay. Yes. So, and you see, this sometimes, look, let's go open. Sometimes we make it look like solely in Ghana. Trust me. In the United States of America, when Trump won, before he won, what did he say? He said if he won, not the second term, the first term, that he was going to appoint justices to the Supreme Court who will vote for him to overturn Roe versus Wade. When we say Roe versus Wade, that's a Supreme Court decision in the U.S. that now bans abortion. There are certain exceptions. We cannot go in there. But generally, you know, under Roe versus Wade, it was easier. Okay, the pregnancy was divided into three, the trimesters. First 3 months, second 3 months, third. And was generally easier first 3 months, second 3, and then more complicated in the third. Right. But overall, Roe versus Wade is generally gone. But the point we are making is that before Trump won, that was his promise to the people that, look, he will get judges who will come and overturn Roe versus Wade. And true, when he became president, Amy Goldman, the Catholic, the Catholic judge and other justices, he selected them well. They sat on it and boom, or if you like, boom, Roe versus Wade was gone. So it tells you that generally, you know, it's something. It's not peculiar to Ghana. We are not saying it's good. Okay, no, that's not. But we're just saying that it's a human problem, and so far we have shown that we are about to take the lead. We are about to make sure that the president doesn't appoint superior court justices and doesn't appoint the chief justice. You know, so for Pufu, he said it she granted an interview. Before she granted it, we even had started. This is a conversation that has been going on. It's been over 10 years since this conversation started that in the new constitution, the president should not be appointing chief justices. We need a different judicial council that would not also have many of the president's appointees. The president will not appoint persons onto the judicial council. It will be independent. And it's that judicial council that will see to the appointment. So yes, we are moving towards there. It looks like JM is ready to give it. Everybody sees that JM is hungry to leave a legacy. It looks like he's hungrier than Kwame Nkrumah, it appears, because he wants to leave his mark on this country. And it's good. It's good we trolled him in opposition for 8 years. I think the trolling has finally, it got to him. And so that the next time I get an opportunity to lead Ghana, I'll be said that even Kwame Nkrumah will find it difficult to beat me. And so far, it looks like it. So even though we've not yet seen the work of the Constitutional Review Committee, it's very clear that generally the nation is moving towards an independent judiciary, at least in the form of appointment. Let's not forget, even when the president doesn't appoint the justices, there are other ways the president can control. You remember Chief Justice Torkonoo, the current Chief Justice, said it, that at a point, Akufo Addo was using money to control the judiciary. He would not release their budgetary allocations, and thereby would be able to control them. So we'll still be then left with the financial independence. So perhaps the chairman of the Constitutional Review Commission, Professor Prempeh, should be looking at that angle too. How we'll strengthen it. Yes, currently, on paper, they'll tell you that, when the judiciary send their budget, you can't cut it and the rest. But practically, there are ways of going around it. So perhaps the committee should be looking at how they can get the financial independence too.
Actually, now, and this is why I bring it, Lawyer Digitamaklo, because I just want to run up on this aspect of the conversation, because it ties directly into the current state of affairs. Is there a real challenge that this call for the review of these powers will solve? Council.
I think that we are faced with an issue that we should not confuse matters. What we are discussing this morning relates to a press conference by the minority leader. He calls himself the mighty minority leader. What that means, I don't know. But what is not in doubt is that the minority leader says that there is an unacceptable attempt by the NDC to infiltrate the judiciary, and now says that civil society groups must condemn that act. And not only that, he invites all other persons, religious leaders and what have you, to tell President Mahama to stop what the Constitution says he should do. Article 146 of the 1992 Constitution is in clear terms. Thankfully, our Supreme Court had the opportunity to interpret Article 146 on the removal processes, particularly as it relates to a Chief Justice. Question: has President John Dramani Mahama done anything today not stipulated by the 1992 Constitution? Certainly the answer is no. Now, President Mahama, having assumed the office of President of the Republic of Ghana on the 7th of January 2025, has received 3 petitions. The petitions are to the effect that, based on the constitutional arrangement, the only basis that you can remove the Chief Justice or a Justice of the Superior Court is 1, through stated misbehavior, incompetence, or infirmity. As I speak to you now, I have not had the benefit of seeing the content of the petition. I have not seen it. Because if you recall, the Supreme Court in Franka J. Chum had provided a certain parameter that the entire process should be kept in camera. Strict confidentiality. So President Mahama, guided by this decision of the Supreme Court, has kept the petition under wrap. In fact, if you recall, when Her Ladyship, the Chief Justice, wrote to him, however, copy to the Ghana Bar Association, Association of Judges and Magistrates, obviously the President expressed his disappointment with that conduct. Her Ladyship, the Chief Justice, demanded of the President, or requested, that Mr. President, I need 7 days to respond to these petitions before a prima facie case can be made against me. Yeah. The President advised properly, said, yes, even your request for 7 days, I'll give you 10 days. That was offered her generously. Let the record reflect that Afenyo Markin, one of the principal advisors of Nana Addo Akufo Addo on legal matters, did not advise Akufo Addo to give Charlotte Osei the benefit of these 7 days or 10 days. That is our record. So it is a mark of, let me say, it is hypocritical, yes, for my leader senior Afenyo Markin to do a press conference and suggest that President Mahama is doing something untoward. It's regrettable.
Well, no, he's not the one who holds that. The argument by the immediate past Attorney General is that to the extent that this injunction application is being heard, it behoves on the President to halt any process ongoing under Article 146 until the determination of that case.
You see, as for Godfred, I won't even talk about him for now. Let me deal with a major issue. You see,
that underlines the position that Markin has taken.
President Mahama's fidelity to the 1992 Constitution is something that should be celebrated. When he became president, he appointed a Shrad boss, yes, called Madame Vivian Loretta Lamptey. Yes. Now get something. Honorable Frank Anno Dompreh, MPP MP, and another gentleman by name Richard Nyama brought a petition to President Mahama that the Shrad boss so appointed by him has misconducted herself, financial issues, and therefore we're seeking the removal of the Shrad boss. Yeah. President John Dramani Mahama, consistent with his character to uphold the rule of law, accepted the petition, forwarded it to the CJ then. The CJ then made a prima facie determination, and the Shrad boss, Madame Loretta Lamptey, then
an appointee of President Mahama,
was removed by President Mahama.
Yeah.
Consistency.
Yeah.
Today, as we speak, President John Dramani Mahama is in receipt of 3 petitions. I don't know the individuals. What has he done, having received these 3 petitions, to warrant that unprovoked, meritless provocation from Afenyo Markin? Has President Mahama done anything inconsistent with the 1992 Constitution? No. He received the petition. The Chief Justice said, President, I have become aware through a press release by your spokesperson, the Honorable Felix Kwachi, that these petitions are in your custody for my removal. Mr. President, before you make any comment further on this petition, Mr. President, I want to respond. The President said, well, I mean, that's fair. In fact, you should have actually spoken to me. Meanwhile, the letter requesting for it, you've copied other people. But that's beside the point. Your request is legitimate. I will give you 10 days to adequately prepare. Now, the president, having done this, was it consistent with the constitution? Due process. He said, look, let everybody, you can't condemn a person without hearing, even though I differ. The president says, I will do that. Now the Council of State or whoever is supposed to go into the merit or otherwise of it. If the Council of State so advise the president and advise that he is not bound by though, what you do, if he sees that there is a determination of prima facie, you do a 7-member, a 5-member committee comprising 3 justices and 2 quote-unquote civilians to determine whether it merits your removal. In the meantime, the president has the power to suspend you. Now, from the time of the receipt of the petition to date, has President John Dramani Mahama done anything outside the strictures of the Constitution? No. Now, listen carefully.
I just want clarity. I'm told that there had been a ruling that says that if there is a petition against the Chief Justice, the President is not bound to give a copy of that petition.
No, so you see,
I'm just asking.
No, so you see, there were 2 schools of thought.
Okay.
That flowing from the Frank Ajechum decision.
Okay.
There is a lacuna. And that at this point, really, because personally, I think that when a petition comes and you respond copiously, it means that on the face of it, there is something that needs to be looked into. Okay. That's my view. And so I strongly believe that even at this point, the question of giving a copy to the person or respondent here is a bit, the Constitution itself is a bit silent on it. Okay. But President Mahama said, regardless, I will give you the opportunity, and gave her 10 days to respond. Now look at this. Afenyo Markin, who addressed the press, one of the principal legal advisors to Nana Addo Akufo Addo until he left office, was here when Madame Charlotte Osei's petition came. Faceless individual. With all the issues, Madame Charlotte said through her lawyers, wrote to Mr. President Nana Addo Akufo Addo for a copy of the petition to respond. Eugene Ahin, the presidential gongon beater, then said, listen carefully, then said, it is not in the place of President Nana Addo Akufo Addo to give Charlotte Osei a copy of the petition. Mahama didn't say so. Mahama said, have it. Madam Sophia Akufo, then Chief Justice, because it relates to, did the prima facie determination. Eventually, the president appointed a 5-member committee. My Lord Justice Benning, the late Justice Mafusa, Agnes Doji, Abrampa, and another woman. They went into the merit and said, look, there is grounds, and recommended the removal of Madame Charlotte Osei. It was a 3-2 majority decision. You understand? So that is our record. Has President Mahama today done anything outside what Akufo Addo has done? In fact, he had even gone a step higher. The lawyer Akufo Addo was not willing to give a copy of the petition. The non-lawyer John Dramani Mahama respected the request of her ladyship, the Chief Justice, and offered her. She even requested for 7 days. President Mahama.
Don't compare President Mahama to
Akufo. Please, gentlemen.
Hold on.
I understand you are unconstitutionally interfering in the submission.
But I'm saying, if you compare,
So I am saying that. Wait. So I am saying that this attack from the minority, and I've heard my learned senior Daku and the minority leader, I see that Afenyo Markin cleverly wants to turn the conversation into an NDC MPP thing to muddy the waters. Cleverly. And if you heard my national chairman, he said, this matter, we are not talking about it, the merit or otherwise. President John Dramani Mahama has so far conducted himself so well. And it's also because he had the benefit of sound legal advice with the likes of the Attorney General, Marietta, and co around him, they will not allow the president, even though a non-lawyer, to do anything outside the constitutional stipulation. And so, you see, I think that regardless of the merits of the petition, and I don't want to go into it, regardless of that, I have seen media houses, some other media houses and colleagues say, oh, the NDC wants to remove Madam, what's her name? Chief Justice Torkonoo, because either than that, the NDC cannot do oral or something.
And that you don't trust the current architecture of the judiciary to prosecute the oral cases.
Let me tell you. I'll tell you.
Hold on.
Shouldn't I beg you. I'll give you a classic example. A case I conducted. So there is a judge.
I'm enjoying listening to you.
There is a judge. My Lord, I'll just use this example. And my Lord Justice Akabuafo, you know him?
Yes.
Okay. Good. My Lord Justice Akabuafo was appointed by President Mahama High Court. Then Nanado took him to the Court of Appeal. Right?
Yeah.
Good. So he strained both regimes. Correct. I did Ato Forson at the appeal before him as one of the Court of Appeal judges. When he saw merit in it, even though he was appointed by President Nanado to the Court of Appeal, he saw merit in our appeal and acquitted and discharged. So for me, the idea that, oh no, because you have been appointed, in fact, her ladyship Justice Torkonoo, do you know who took her to the Court of Appeal? Do you know who took her to the High Court? She strained all the political parties. So this has nothing to do with whether she was appointed by MPP or NDC. What we all need to do is soberly reflect, and I'm sure if a prima facie determination is made, we'll all have the benefit of knowing. Look, in the case of Charlotte Osei, and remember that when Charlotte Osei matter happened, Frank Ajechum had already been decided. As at the time, Nanado Akufo Addo forwarded the Charlotte Osei petition to her ladyship Chief Justice, I think so far Akufo, right? And she made a prima facie determination. What was it on? Procurement breaches. I remember at that time, I cautioned. I said, no. Superior Court judges, because of the countervailing force in our democratic experiment, right? The ground for their removal should be something very serious. At that time, my friends in the MPP, my friends in the MPP said, no, it matters not. Procurement breaches is enough, and that constitutes stated misbehavior. I said, look, the Procurement Act itself envisaged the possibility of violation and provided in Section 90 the opportunity to rectify. And so, in the wisdom of the maker of the law, they envisaged a situation where there could be mistake. So they said, set up a committee, investigate the matters. If the committee now makes... So I was looking at the situation where before you can remove a judge, it should be on grounds that he has stolen public funds. There's some... Our friends in the MPP said no. And I remember, and I said this with so much sadness. Kweku Annan issued a writ at the Supreme Court. His lawyer was Samson Ladi Ayenene. That day, I happened to be at the Supreme Court with my senior Dr. Ayene on a different matter. That same day, the Charlotte Osei suit came. Kweku Annan suit came up. His Lordship Justice Nana Megache asked Samson Ladi, Samson, are you saying that a breach of the Procurement Act is not a violation of a law, is not stated misbehavior? And that was it. That day, I left the court sad. I said, look, if we put it in that context, all of us become vulnerable. The level of vulnerability is high. But I think at that time, it was convenient for some people to do that. Possibly because it was Charlotte Osei. And I've always maintained, that tomorrow is pregnant. The accounts have a say, yes, oh, you are for son. Now, why are they? Why should one son? Look, why is Afenyo Markin panicking? Does he have the benefit of the petition and its content?
Well, there's been some references made to some allegations that they, by minority, purport to be in the petition, which they describe in words as frivolous. In fact, the current Swami Member of Parliament, John Darko, addressed the press this week, referencing some allegations purporting to be in the petitions against the Chief Justice, and the description given to those allegations that they are frivolous. I want us to take a listen to
so that I can come.
John Darko, let's take a listen to John Darko.
Let's listen to
quickly.
John Darko. Then I can
and then I will set the matters in context. Take a look.
We are told that a gentleman who committed contempt in Sackéd Courier and was thus accordingly punished by the courts was the CJ because he has been punished by the court, not the CJ. One of the last allegations we've heard, which is ridiculous, is the fact that the CJ has misappropriated some 75,000 Ghana cedis. An accusation which from the judicial service has been dealt with by the Auditor General's outfit. Justice Torkonoo's distraction should not be the grounds for your rising to the office of Chief Justice. To you, that judge, remember that you can rise together. But if you ride on the distraction of somebody to rise, remember that posterity will not be kind to you. To our development partners and foreign missions in the country,
So that's John Darko. Hold on, because this, by the process and details of Article 146, the details of the petition is supposed to be income rights, secret. We shouldn't know.
So
but then again, the reference is made of the allegations.
My learned senior says we are told. Now, when the president had the benefit of the petition, and the Chief Justice wrote the request, the president, in honoring the request, sealed the petition before giving it to her. Who informed the minority of the details? If Her Ladyship, the Chief Justice, in communication with the minority, because at this point, the petition is between the president and the Chief Justice. And in fact, for the president to guide the integrity of the process, he sealed, he marked the petition. I've heard one other journalist of Metro refer to what they claim to be the content of the petition. Who leaked to them?
That is, if it the details.
No, but this one he phrases that we are told.
Yes.
Who told I listened to him carefully.
No, I just played that.
Who told him these contents? But you see, how come that he, John Darko, his own colleague, Afenyo Markin, Dompreh, brought a petition for the removal of Loretta Lamte. President Mahama didn't say it was an MPP MP against my appointee. He received the petition, actioned it, he found merit, and dismissed his own appointee. How come that today, Anno Dompreh and his minority do not have confidence that President Mahama would do same thing he did to Loretta, affording her the opportunity to defend herself? Where is the fear? Where is the panic? You see, the stand of the minority relative to this broader national issue actually betrays a certain thing. It is extremely revealing. What is it? In all these constitutional arrangements, there's only one person under Article 146, to perform that role of receiving a petition, it is not Professor Ranford Jampo. It is not my learned friend here or this big man, not even me, only President. The President. Who is the President of Ghana? Possibly the petitioner should have addressed it to the MPP minority
before
and given it to Afenyo Markin so that Afenyo Markin can consult the Council of State in this process. Malene Senior, you were called to the bar before me, and I've always been inspired by your legal work. What exactly is the complaint against John Mahama? My senior George Dako, what exactly is the complaint against President Mahama? Now, when you assume the position of now deciding that a petition is frivolous, are you not usurping the powers of President Mahama and the Council of State? Lawyer Dako, it is rather your conduct that is unconstitutional. It is rather your conduct that is unbecoming of a lawyer. President Mahama so far has only conducted himself within the confines of the law. Akufo Addo did it. The three commissioners of the Electoral Commission were all removed through that process. President Mahama has not invented a new rule. He's just basically holding fidelity to the 1992 Constitution. I think at this point, the minority must stay away and allow President Mahama to perform his constitutional responsibility. If there is any merit, and I've always said, thankfully, the Council of State has a retired Chief Justice on that committee. Her guidance, and in fact, thankfully, she even is in a very interesting situation. You know why?
Relationship.
No, Charlotte says prima facie determination was made by who?
by her.
By her. So if there's anybody that has that experience, she'll bring that experience to bear. What did she see? In fact, if she's somebody who could make, yes, if she could make a prima facie determination for the removal of Charlotte on her own, or even that one on her own, because remember that the process is different. If it comes to the Chief Justice, it's a different rule. But for other Superior Court judges, it's the Chief Justice that makes that determination. And she found it that in the case of Madame Charlotte Osei, the evidence of breaches of the Procurement Act was enough to warrant the establishment of the 5-member committee chaired by His Lordship Justice Benny. Has President Mahama done otherwise? No. So away from this, complete red herring. But it is actually an emotional conversation now. Because you see, CSOs, you must stand for the judiciary.
I'm here, I will speak.
Has President Mahama, as we speak, President Mahama, has he appointed any judge?
No.
Has he appointed any judge?
No.
So where from the interference? Has President Mahama asked that a particular judge should sit on a case involving him or his government? No. If there was any evidence of judicial interference, kindly look at the African peer review report in 2004. No, 2005. Even though it reflected 2004. When the Chikata trial, the fast-track composition, where in the midst, President Kufuor appointed Justice Afre to the Supreme Court and got onto the panel that reversed the original fast-track decision. The African peer review mechanism report indicted the president as directly interfering in the judiciary. President John Dramani Mahama does not have that reckless record. So where is the conversation going? President Mahama, on the 7th day of January 2025, in taking his oath, said, I shall respect the 1992 Constitution. What Afenyo Markin and his micro minority are doing is to say, President Mahama, disobeyed the constitution, which will now be a ground for his removal. Because remember that if the president disobeys the constitutional order, that's grounds for his removal.
Indeed.
At this point, with all the counsel available to President Mahama, he is fortified not to obey that recklessness, but to stick to what the Constitution says.
Right.
Let's see what the coming days will reflect.
Indeed, but well,
you're waiting for winning and someone about better. So make out say so we don't subscribe to channel idea, but more than say over subscribe. Now, while like video, don't give us a thumbs up. Now, share my work for so now when you be here now and somewhere also ever Ghana memoir. Also, bet me otchere wondering afai and some way you know our comment box in more. Obeti make a beam in my next video.
Thanks for watching. Like and share the video. You can also drop your comment. Please don't forget to subscribe. Click on the bell to turn on the notification.